Hi friends from around the world. Today is a sales day, meaning they have at least three procedural orders of the court instead of one judgment. Judgment and order, you know what the difference is. Order is when it is apparently not admissible, or they are not substantiated, or it is clear from the beginning that it has to be rejected, or on costs or so. So if it is a quite straightforward case, then it would proceed to an order. Otherwise, there would be a judgment, and this is procedural based. Here the three orders, so it is an order. Now the first is, here it is on the screen, 193 of 20 from the 9th of July 2020. You have to know that there has been in 2019 a change of procedure with regard to appeal to the European Court of Justice, so the second instance, the last instance on the European jurisdiction level, appeal from the General Court to the Court of Justice. And one of the changes, the changes were intended to make it more difficult, to make less cases to go to the Court of Justice, so not to jam, so to say, the circuit of the court. And it has been achieved. So, and there is Article 170A of the Rules of Procedure, which says that the appeal has to be, there has to be a brief appeal brief, substantiation, and on top of that, there must be a briefing of a maximum of 7 pages with regard to the admissibility of the appeal, in the sense that it proves that there is either unity of jurisprudence or development of law or consistency of law. There are these issues which comes into play so that the appeal will be admissible. 7 pages. 7 pages, which cannot be beyond that. And on top of that, there is Article 42 of the practice notes. So you have the statute, you have the rule of procedure, and you have the practice notes, which says a bit how these 7 pages have to be formatted. So there must be the current fonts like Times New Roman or Arial, which must be used, and the spacing must not be lower than 1.5, and the footnotes must be in that on the other format, and so on. So it goes quite into very much detail in order to comply with the 7 pages. Now in that case, I'm coming now to the case C193 of 20. In that case, there was the additional brief with regard to the admissibility procedure was too long. So, it was the 7 pages, but the spacing was too low, was less than 1.5. So it was still within the 7 pages limit, but the formatting, according to Article 42 of the practice notes, were not being respected. So what the court did in that case, it told the applicant that there was not compliant, and give them a possibility to remedy within a certain time limit, which has not been done. So it has been rejected. The order has been rejected. Now in 2020, there were 2 more where no briefs, no such admissibility briefs have been presented, and all have been rejected. So on little things, that is what I want to point out. On little things, all what has been put into an appeal, and probably before in the General Court. So 2 proceedings which have been done, lengthy proceedings, and lengthy work has been put into it for nothing. At the end, nothing. So the details are quite important. Now let's come to another case, which is C455 of 2018, which has been decided on 8th of December 2020. It is about representation. There is Article 19.3 of the Statutes of the European Court of Justice, which says that one must be represented. And it is about the representation here where we get into troubles. The appellant was a lawyer, a German lawyer, who was part of a law firm, right? So an individual, he was a lawyer as individual, and he was on top of it part of a law firm. Now in previous proceedings, he figured as the individual appellant, and one of his associates in the law firm was the lawyer. So there was a representation between one and the other, although both of them were in the same law firm. That was no problem. Now, with regard to the appeal to the European Court of Justice, he said, the individual, the lawyer, but the individual, as an individual, he said, well, my associate was not available at the time when I had to present the appeal, and then I signed it. In any case, there is no problem because there is no signature, so to say, needed, because at the Court of Justice that functions electronically, meaning that there is only a kind of electronic signature, which is not a signature, but which is just a recognition that you can do it. And he could do it because he was in the same law firm, right? Now, the Court of Justice proceeded to an order in the sense that, well, it was not possible. Representation means there must be a third party, so you cannot represent yourself. Although he was a lawyer, so representation in general, professional representation, means that there must be a lawyer which is being recognized to act as a lawyer in front of courts in a member state. So there's an intertwist between European law, which recognizes only what has been recognized in the member states, that you find often that is a mixture between European law and national law. So let's come to a third case. That is C174 of 2020 from the 3rd of September 2020, and it's about the absolute deadlines. So you know that is an appeal deadline. Appeal deadline is 2 months, so it is across the board. It is from the opposition, is from the cancellation, it is appeal, it is the General Court, and it is also the Court of Justice. So 2 months. That is Article 56 of the Statutes of the Court of Justice. And we have in the for the Court of Justice, so we have an additional 10 days, that is Article 51 of the Rules of Procedures, 10 days on the account of distance. So that comes way back when you needed to make a postal and paper appeal, and if you are in, I don't know, close to the border of the European Union in Romania, it takes longer than you had your seat in Luxembourg. So in order not to discriminate one against others and not favor all the people in Luxembourg only, it was put that there's a distance rule plus 10 days. Now there was an appeal which has been introduced by a party, and it says the following: though the 2 months deadline elapsed in the 12th of April 2020. 12th of April, 24 hours, right? At the end of that day. So that was a Sunday. 12th of April 2020 was a Sunday. And Monday, 13th of April, was a holiday. So the reason was, the reasoned opinion of the appellant was, well, if the 12th is a Sunday and the 13th is a Monday, holiday, so it will end, the 2 months will end on the 14th, only 14th at midnight. So the 10 days would be added to that, the distance days. So he had until the 24th of April to introduce the appeal. Now that was dismissed by the court. The court said that the 2 months ended, and there's a 2 months plus 10 days. So you have to add 2 months and 10 days in order to get to the right moment of appeal. Whereas if there is in the middle, there's a holiday and another holiday, so that doesn't matter. So in reality, what you have is not a calculation of 2 months. And you make that calculation and then you say, well, from now on, I add also 10 days. Is not like that. It is 2 months and 10 days, and whatever it is, there it is. In that case, it was the 22nd of April. So that was the problem, and it has been dismissed. So there are just little things, right? Little things, procedural things which you don't know, which you have to know, which are details. You may have this around the world as well, but this channel is about European law and what is in the Court of Justice. So it is just to tell you that these little small differences, and maybe one of those reasons or procedural problems we have here, it may come back to you in your home jurisdiction, where you then can apply what you have seen in Europe, what has been reasoned here. It can also be a trigger in your home jurisdiction. Hopefully it is like this. Well, the lawyers are, the same reasoning applies lawyers across the globe, so there is no much difference. It is that the law is different, yes, but the reasoning behind is not much different. So procedural things. I hope you liked it. Thanks for tuning in.